about 500,000 views on that channel. So it's pretty fun.
Very
So
creatively called Gilfix Law.
Gilfix Law, hard to
We
find
have
these.
no imagination, but
Yeah, I know. So yeah, I think we're gonna give it one more minute and then we'll officially jump in. I see quite a few people have joined us and quite a few more have registered. So we always want to give it just a minute or two more, and then we'll jump in. We'll keep this under an hour, and we're going to go pretty quickly through a lot. So again, welcome to everybody. It's going to be a really important topic. If you have anybody in your family or anybody you know, friends who have a disability or special needs, you need to watch this webinar. You need to take some notes. We're going to post this on our YouTube channel as well. So take a moment and get comfortable. And I think I'm going to start sharing our slides and then we'll officially get started. All right. Can you see that slide, Mike?
oh yeah, that's golden. Very good.
All right. Well, why don't we officially get started? So welcome, welcome, welcome. I'm Mark Gilfix. I'm here with Michael Gilfix, my father and colleague. We are talking today about special needs planning and special needs trust, what you need to know. What do you need to do if you have a loved one with special needs? How can you make sure they're taken care of? That's what this is about. And if you haven't, please subscribe to our Gilfix Law YouTube channel. We have this and other great content. We have short videos, long videos of all types, a lot about special needs planning. You can also spread the word, share this with anyone who might benefit from it. So let's jump in. So special needs planning is just such a crucial issue. And before we even jump into the content, I want you to take a moment and think about why you joined us here today. Are you concerned about your child with special needs? Are you worried about their support after you're gone? Are you scared? Do you have sleepless nights? Or do you just feel like overwhelmed? I think many of us feel overwhelmed about the world today. There is craziness. We're going through a very crazy time. And we hear this all the time, literally all the time. I'm afraid to die. And this is especially poignant for parents of children with special needs. And this doesn't refer to the parents' fears about their own mortality. This is really about what can I do for my child after I'm gone? How can I be sure they're cared for? Because so many of the parents that we work with, they are the safety net for that child with special needs. They are the financial safety net. They are the guardian. They are the organizer. They are the caretaker. They do everything. What do you do after you're gone? And I think so many people are absolutely terrified of what will happen after they're gone. Now, this talk can't solve all of those issues, but can help you think about ways to solve two big pieces of that. And that's the legal and financial side of your child's future. So that's really what this is about. And as we jump in, I want you to reframe how you think about this. It can feel kind of hopeless at times, right? When you're thinking about the future. But I think some things I want to emphasize, hope is not a strategy. Hope for things just falling into place in the future, that is not a strategy. I was a management consultant for many years before I was a lawyer, and we use this all the time. Hope is not a strategy. You need a strategy to deal with your fears and control what you can control. If any of you here have been through a crisis, I've been through my own health crises. My wife has. She had breast cancer a few years ago. I faced my own cancer journey a few years ago. And when you're facing a crisis, you have to get narrow focused on just what you can control. You have to let go of what you can't. And that's what this talk is about, is what can you control when it comes to special needs planning? And we're here to go over what you need to know for an unstoppable special needs plan. And I just want to, before we transition to the contents of the talk, I really like the serenity prayer. I don't know how many people are familiar with that, but just as a reminder, whether you're religious or not, I think it's beautiful. So God, grant me the serenity to accept the things I cannot change, the courage to change the things that I can, and the wisdom to know the difference. And I think that's core to what this is about. When you have a child with special needs, there's so much you cannot control. Yeah, you're going to worry, but let's focus on what we can. And let's make sure that you and your loved ones are empowered with all the legal and financial tools available to give your child an abundant and powerful, beautiful future. So what are we going to talk about here today? There's a lot we're going to cover. Let's go through this. So the specific topics we're going to go over: how you must structure your estate plan. What is a special needs trust? And what are the other documents you need to have in place and up to date? Because it's not just the special needs trust. We're going to talk about new property tax laws in California. If you follow us, you know we talk about this a lot, but it's absolutely crucial. If you own property in California and want it to be there, for your loved one with special needs after you're gone? And do you have enough? How can you build that financial safety net for your loved one? Make sure there's enough there for them. We're going to talk about some brief updates in law around special needs planning, just a couple. We're going to talk about the estate tax cliff that also impacts special needs planning. And lastly, we're going to go through some checklist items. What do you need to do now? What are some steps you can take right now to secure that abundant future for your loved one? And we always have to point out this is for educational purposes only. This doesn't create an attorney-client relationship. This is just for you to understand. We always have to work with you directly to really help you and to really form that attorney-client relationship. You got to work with us specifically, but we hope this empowers you with information. And we're going to go through a lot, so bear with us. And we will take questions at the end. If you have questions, enter them in the Q&A function if you're watching this live. If you're watching this as a recording, enter it as a comment. If you have questions as we go, we'll try to get to questions at the end, because there's a lot of questions we usually get in this area. Mm-hmm. So just really briefly, for those of you who don't know us, we are Gilfix La Poll Associates. We are national leaders in special needs planning, estate planning, elder law, over 40 years now in Palo Alto, but we serve clients throughout the state of California. So if you're in California, we can help you. We work with people from San Diego all the way up to Wairika. We are a multi-generational team. As you can see, we have Michael, Gilfix, Francis La Poll. They're the elder statesmen, not too old, but they've been around for a long time. And we have several younger attorneys as well. And we serve thousands of people throughout the state of California. And we've done special needs planning since the 1980s. So our goal is to provide extraordinary return on investment and value for when you work with us. We want to make sure that you get peace of mind and incredible value. We're very proud. We've been featured in the national media many, many times. Mike has many articles in Bottom Line Personal Magazine recently published. Our YouTube channel has been seen by hundreds of thousands of people now, and we give a lot of talks in person. And really importantly, Mike, you and I wrote a book about special needs trust planning. So just brief intro about the book that we have.
Yeah, I mean, the focus of this book is practicality. The challenge in writing this book for the two of us was to make it sufficiently brief that people would read it. You know, that inverse relationship. The longer it is, the less likely anybody will read it. So it's a very serious effort to make everything understandable, comprehensible, and really help you see how all of these pieces of the puzzle fit together. For our clients, it's free. We charge a really modest amount when we do sell it. I believe it's the best thing out there. It's brief and to the point.
And it's available on Amazon. And if you work with us, we give you a copy. But I think the main point here is we think about this a lot. You know, we've written a book about it. We're probably going to update it soon. So on that note, let's transition to another line that we hear all the time. A diagnosis changes everything. When you get that news from a doctor or a specialist that your child or someone in your family has that issue, whether it's a disability, a medical issue, a mental health issue, your world shifts, right? We hear it all the time. What is the key tool that you need to deal with this when you hear about this? Mike, why don't you talk about what a special needs trust is and how it fits into an overall estate plan?
As a general matter, a special needs trust is a necessity. If you have a child who may not be able to work, the test of disability in this context, by the way, for government benefits is not the particular diagnosis. It's whether or not the individual can get a job and keep a job. Can they make a living? And if not, they are disabled in the context of government benefits. And many of them have asset and even income criteria that have to be satisfied. Bottom line is, when you set up this irrevocable trust for the benefit of your child, any amount of money can be in that trust. None of it counts. None of it interferes with eligibility for government benefits. They're not one size fits all. Some people have need to be in an institution, some at home. So it's fine-tuned to make sure that it fits properly. But again, it's the key element to hold assets for your child, to provide a lifelong safety net, to make sure that in addition to any government benefits, there are also resources in this trust to make sure that your kid is taken care of for life. And then the trust ultimately says what happens with those assets when you pass.
Right. And very importantly, you're naming the person or the entity who will oversee that trust for them. So you're making sure that a trusted third party is always overseeing this money for the benefit of your loved one as well. So, Mike, why don't we talk about the different types of special needs trust, first party versus third party? What are these terms? How are they relevant?
Of course, these are nicely described, summarized in our book as well. The typical trust that is created for a child with a disability, or for a sibling, by the way, or sometimes even for a parent, is where the parent creates the trust for the benefit of the child. And that's what's called a third-party trust. The idea is some third party, somebody other than the child himself, is putting the money into that trust and creating it. So again, typical trust, parent creates it for the child is the beneficiary. Key point, Upon the death of the child, upon the passing of the beneficiary, the parents decide what happens with money remaining in that trust. Does it go to other family members? Does it go to a charity? It's up to the parents. The state doesn't touch it. There's the difference with the first party. The first party special needs trust is where it is the disabled individual's money that goes into the trust. So if somebody's hurt in an accident and they're newly disabled, they can create a first party special needs trust. They don't need anybody else to do it. They can shift all of their money into that trust and they immediately qualify for government benefits. That's a transfer that doesn't interfere with eligibility. The key difference here, again, is that with the first party trust, there must be a provision saying upon the death of the beneficiary, before anybody else gets any part of that money, there must be reimbursement to the state of California for Medi-Cal benefits and perhaps other benefits that have been paid. So again, that's the crucial difference. 9 out of 10 trusts are third party, but there's a significant number of first party trusts out there as well, which we do routinely.
I think a question we get a lot is, if I create a special needs trust for my loved one, can the state go after it after they pass away? And it depends on the type of trust. If you create it for them and it's your money that goes into it, the state cannot touch it. If the money goes to your child first and they have to create their own special needs trust, then the state can go after that money when they pass away. So that's the third party versus first party necessity of planning ahead when you can. So and I think it's really important. It's not just a special needs trust. It needs to be part of a comprehensive plan. Mike, any comments about the overall?
So when we're setting up the special needs trust for the child, for the beneficiary, and 9 times out of 10, it's the child. But again, it could be other family members. It could be a sibling. The parents must also create their own living trust because they have to direct money in their estate to the special needs trust. It doesn't happen automatically. So the trust needs to be coordinated with the special needs planning, powers of attorney, and the advance directives, both for the parents and ideally for the child, by the way. Many individuals who are disabled and can't work have a sufficient level of capacity to sign their own power of attorney and to sign their own advance directive. And often, by the way, that's a key to avoiding the need for a conservatorship, where you have to go to court and a judge appoints somebody to manage affairs. So all of these pieces of the puzzle need to be coordinated. They need to fit. They need to be done for both generations, ideally. But again, the point is to address the special needs challenges in all of these documents, just to be sure that your child is going to be taken care of. So again, very important point. You have your irrevocable trust. We all have that, or we should. The special needs trust is created now. It sits there empty, waiting for you to fund it while you're living, or more typically, it's funded upon your passing.
Exactly. Here's a simple, very simple summary of this. Mom and dad have their own separate living trust that needs to be up to date. It needs to say that, let's say you have a daughter, Sarah, who has a disability. You do not leave anything to Sarah. You create the special needs trust for Sarah separately ahead of time. And you say, upon my passing, I'm not leaving money to Sarah. I'm leaving it to the special needs trust. And you need to set this up ahead of time. And we only do this where we create the special needs trust as a separate document, a separate entity. It should not be embedded in your living trust. There are many reasons for that. One of which is you may want to put money in it while you're still living. And if it's not a separate entity, you can't put any money in the special needs trust until you're gone.
And by the way, as we did for some clients just yesterday, it was a grandparent who wanted to leave some money for the benefit of their disabled grandchild. Yep. They were going to leave the money directly to her, which would have been a small scale disaster. They learned that we prepared a special needs trust, the parents did. So the grandparents, they were leaving about $10,000 to the special needs trust. It had to be a freestanding separate entity, couldn't be embedded, waiting to be created upon the parent's death. So again, how 3 generations can fit together.
Yeah, absolutely. So we get the question a lot too of, well, if I put in a special needs trust, isn't that really limited in what it can pay for? Like, I don't want to limit it only to things that government benefits don't cover, because government benefits barely cover anything these days. It's not enough. So what can a special needs trust pay for when it comes to your child after you're gone?
I think the way you think about the use of funds in a special needs trust is that they are there for the quality of life of your child, whether it's medical care or enjoyment or housing. The money can all be used. There are some limits in limited circumstances, and most of those limits are avoidable and they don't create a problem. So the real bottom line, and you see a list here of some of the more obvious uses of money in a special needs trust, it's virtually anything that's needed for the quality of life for the beneficiary. And there's great flexibility to the trustee, the person who's managing these funds, to make sure that everything is handled properly, and again, that the child is well taken care of.
Exactly. Now, I know what you guys are probably thinking. You're thinking, well, food and shelter, all that stuff is nice, but can special needs trusts pay for, let me share this visual, Britney Spears concert tickets? Yes, they can. Okay, now Britney Spears is obviously not quite as relevant now. No offense to Britney Spears, but this is actually based on a real case. There was a case where someone was challenged for using special needs trust funds to buy Britney Spears tickets for the beneficiary, and it was found that that was okay. So maybe today it's Taylor Swift or someone else, but there is an actual case about this. And I think this just points out that you can be very flexible with how special needs trust funds are used for the quality of your child or loved one's life after you're gone, or even while you're living, if there's money in it. So I think that's really important. I always like this example because it really makes the point. It's very flexible. Let's talk about a really important topic, and this is more than just for special needs planning. But what is a trustee? We get this question a lot. And then how does it relate to special needs trust? And how do I choose a trustee? So, Mike, why don't you give us an intro on what a trustee is, and then what the role means in a special needs trust, and we'll talk about how to think about who you choose in that role.
Whenever there's a trust in existence, whether it's a revocable living trust or a special needs trust or a dynasty trust, somebody has to manage those assets. Who's in charge? So that's the role of the trustee. The trustee controls and makes investment decisions, decides how to distribute the money, is guided by the language in the trust. So again, in a special needs trust, it walks through the issues that can come up in the context of special needs. The trustee is the key person. It is not uncommon for there to be a 1.5 hour new client meeting, and 45 minutes is focusing on the choice of the trustee, because parents realize after they're gone, this is the most important person in your child's life. They're going to be controlling your money and therefore very directly controlling the child's life. So that choice, very complicated. So let's walk through the way we think it through, the way you might want to structure your thinking as you decide who should be the trustee of the special needs trust. And let me say by way of introduction, this isn't a matter of who do you love the most. It's not a matter of who's the oldest kid. It's really the question of who is going to be responsible, take the job seriously, be attentive to the needs of the beneficiary, and just do a heck of a job. It's demanding. It's a really serious role. So as we walk through this topic, we always think first about family members. Are there any family members who would be willing to serve as trustee? And by the way, even family members are compensated. They should be compensated for serving as a trustee. In a way, I like to point out the ideal family member to be a trustee of a special needs trust in so many contexts would be your child's cousin, who is a CPA, who lives in Omaha, who has nothing but time on her hands and knows and loves and understands your child. There's your ideal trustee.
Yeah.
A little distance can sometimes be a good thing. That person never exists. But there are other family members. There are siblings, and you really have to be careful about that. The relationship between your child with a disability and another child is a precious thing, and you never want to erode that, but it's a factor.
And a trustee's job is often to say no. It's to say, no, I'm not going to give you a bunch of money to go on a bender in Vegas, or no, I'm not going to buy you a Lamborghini. So
often that comes up so often when there's a mental health issue, bipolar, schizophrenia, or just lower levels of concern about somebody's very challenged level of logic as they make decisions about their lives. So you have to say no sometimes. So if a family member,
go ahead.
Okay, so if a family member is not available, where else can you look? There may be very close friends, maybe a godparent to the child, somebody who you've known forever and you trust. Of course, you could look there as well. If you don't find anybody there, you have to look to individual professionals. There are fiduciaries. There are people in the business of serving as trustees of trusts, including special needs trusts. Many attorneys will serve in this role. Fiduciaries in particular will have a minimum level of money that has to be into the trust because it has to generate fees for them. If you're going to look to the world of professional fiduciaries, you have to look at the age of the individual. Some of the fiduciaries we know best are already in their 60s, and if your child is in her 30s, it's not going to work. So we have to find some younger people who are professional trustees to potentially serve in this role. If you don't find somebody there, in a way, the fallback would be an entity. Now, this is typically a bank, a financial institution. Some will serve as trustees of special needs trusts and some won't. They may have a $1 or $2 million minimum because it has to generate fees. It has to make financial business sense to them as well. There are a limited number of nonprofit organizations that will also serve as trustees if you can't find anybody there. If it's a very small amount of money that's going to be in the trust, which we encounter from time to time, there's something called the pooled trust. So there are alternatives. We understand them. It's a matter of walking through them, being educated about each of them means, and then making the right decision. It's so critical.
And how much does a professional trustee get paid? Or
Yeah.
family members? There's usually two broad structures. So I'll just quickly go over that. So some professional, if it's a family member, they can keep track of the time and they can pay themselves a reasonable hourly rate that varies on the community, their level of experience, the level of work. Professionals either charge an hourly fee. They can range from, we've seen $150 to $350 an hour, or increasingly most professionals and banks will typically charge a flat fee based on the size of the trust, often around 1% per year. So, a couple $1 million trust, 1% of that, $20,000 a year. It's a sliding scale. The larger the trust, maybe it's lower, but you have to keep that in mind when you're thinking about who you're going to name. And as Mike said, we encourage family members to compensate themselves. We want them to devote the time needed. Very importantly, they can use trust funds to get help. They don't need to be legal or financial experts. They can hire attorneys with the trust funds. They can hire accountants, hire financial advisors. So they don't need to be legal or financial experts. But it is really important they do a good job. I mean, that's what matters. So
and let me add, they can also hire a social worker, a care manager to visit the beneficiary. It is not the job of the trustee to do everything, to be hands-on, to see everything. You have to use the money in the trust so that the trustee doesn't get exhausted.
exactly.
Again, it's taxing. So we have to be balanced as you think these things through, and make sure that your choice of the trustee knows that he or she is going to be in that role. Make sure they'll
Absolutely.
accept it.
So just to revisit a really important point, we talked about the fact that a special needs trust is not something you just do on its own. It's really important that your special needs trust is part of an overall estate plan. Not going to spend too much time on this, but it's really important just to revisit this because there's a lot of confusion about that. I think, oh, I have a child with a disability, I'll create a special needs trust. We touched on this, but you need to have your own, mom and dad need their own separate living trust. The wrong structure, by the way, if you set up a living trust years ago, the wrong structure, whether it's AB or non-AB, could potentially cost your child hundreds of thousands of dollars, or their trust hundreds of thousands in unnecessary taxes. So revisit that every few years. Sophisticated, durable powers of attorney. Everyone over 18 should have a power of attorney. This says if I'm incapacitated, you name the person who can step in and deal with your day-to-day finances. If you have a child with a disability, it's really, really important you don't have a simple check the box power of attorney because you need to address special needs issues. If your child's over 18 and you're supporting them, you need your power of attorney to address that. You need to say, if I'm out of it, even though my child's over 18, my money, you can use my money to support my child. Because remember, if you're still living, there may not be any money in the special needs trust. So it cannot be a check the box form. You need to have your own advanced healthcare directive. So if you're in the hospital, someone can make medical decisions for you. We can, of course, help with it all. Really important to have an integrated, holistic plan that addresses all of this. Your trust should link to the power of attorney, which should both have special needs provisions. Your trust should leave money to the special needs trust, not to your child directly. So really important that your estate plan is strong and that it addresses special needs trust issues. And just some really high level issues you need to think about. Your living trust structure, you need to take a fresh look. If it's been, maybe you have a plan, maybe you have a special needs trust and a trust. If it's been a while, we need to take a look at your living trust structure. AB, non-AB, do you even know? That might have a massive tax implication for your loved ones and for your child with special needs. Should not be simple off-the-shelf documents. When there's special needs, we need to make sure it's specific to your child. We need to make sure that you have the right trustee's name. When's the last time you adjusted your backup trustees or you revisited them? Does the special needs trust have the right trustee's name? Do you have the right backup trustee's name? You need to revisit that every time, and you have to make sure that your power of attorney is integrated. You need to make sure that your retirement accounts are properly titled, your beneficiary designations are up to date. There's a lot of pieces to this. It's really, we are big believers in working with integrated teams. We work closely with many financial advisors. We have our own network, but it's not just the special needs trust. Your plan is only as strong as the weakest link. So it's our mission to make sure that you have an integrated plan. So your plan has to be up to date. Special needs trust has to be up to date. And there's a lot of other moving parts. So we can help you with all of that, of course. So just make sure it's not just this one document. So I want to transition now to a really, really important subject. If you live in California and you own property, you need to watch this part. This is really important. If you follow us, you know we talk about this all the time. But Prop 19. It's a new law in California. We want to talk about the savage impact of Prop 19 on special needs planning. So I think this is the issue. It's homelessness. Look at the streets of San Francisco and how many people with mental illness are roaming the streets. We have clients who spent years getting their son off the streets of San Francisco. It took a Herculean effort to get him back off the streets. But what if you're gone and there's no home available? The odds of homelessness or problems are just beyond challenging and scary. You don't need me to argue that home prices are going up and that housing is extraordinarily expensive. Prices are going up, interest rates are high. So if you're lucky enough to hold or already own property and you want to leave it for your child with special needs or their special needs trust, you need to be aware of Prop 19, this massive change in California law. Mike, please introduce us to Prop 19, what it means and how we can deal with it.
So I think the first thing to understand is that Prop 19 amended the California Constitution. And that's very important because it means that the legislature can't address it. The legislature can't fix it. It would take another voter initiative. And we'll talk about that in just a couple of minutes. So by way of background, we're all familiar with Proposition 13, right? It rolled back property taxes. Everybody loved it. Good for elders, et cetera, et cetera.
Everyone who owns houses loved it, by the way. People who don't own houses maybe don't love it so much.
Well, Wells Fargo was the biggest winner, by the way. That was the biggest property owner in California at the time. And the Prop 13 wasn't just for individuals. It was for any property owner, but that's an aside. All
Yes.
right. After Prop 13, we have Prop 58. And it's important to mention that because it is Prop 58 that our new proposition gutted. Prop 58 said two things. At first, it said that your home, your residence could be passed along to your kids without a property tax increase, carrying over the Prop 13 level, whether or not your kid lived in it. So the property taxes would not go up, period, regardless of value. It also said that another $1 million in assessed value into real property could also be passed along to your kids without a property tax increase. So you could have a home worth $2 million, assessed value $400,000. It would also be passed along without a property tax increase. That could be a rental. It could have been a vacation home. Okay, then comes Prop 19, and it guts all of that. It eliminates those benefits, excuse me, and those protections. So we have one approach taken for the residents and another for rental property. So let's look at the primary residence first. Notwithstanding what some published articles said, it is not the case that the property tax increase is avoided if your child makes your residence his or her residence. There is a partial break there, but it's only partial. So here is the bottom line on the residence. If a child makes the residence his or her residence, and they have to take a number of steps to establish that, the first $1 million in assessed value is forgiven. So if you're paying $5,000 a year and now the property is worth $3 million, if your child moves in, the new assessed value would be $2 million because the first $1 million is forgiven. Property taxes would still increase to about $24,000 a year. So it's not a complete level of protection. And sometimes there's no child who's going to be able to move in. So
we'll give some examples. We'll break down some actual numbers in a moment.
Sure. And I think as importantly, and sometimes more importantly, if it's not the residence, there are no protections whatsoever, none whatsoever. In the context of special needs planning, how many folks are thinking of your residence being there for your child? How about you who might have a small rental property or a duplex you bought for your child or a condo, and the vision was that your child would live there and it would be in the special needs trust? Well, now that's going to have a property tax increase. So it can be devastating. It can eliminate the ability of your child to retain ownership of your property because the property taxes are set, because the hit is so big as we go forward. Tens, hundreds of thousands of dollars.
Right, and you can leave real estate to a special needs trust. So same impact with this if you're leaving it to a special needs trust. And we get this question too: will Prop 19 be repealed? Because a lot of people are trying to work on that. And I think the answer is, at least for the next few years, no, it's not.
Yeah.
There have been 2 attempts to do it, and they've come far short.
Yeah. I mean, a couple of quick points. And we have to realize that the vast majority of Californians are not really going to be harmed by Prop 19. Either they don't own real property, they're renters, or maybe they own a residence and it's worth $1.1 million or less, which is the case in large swaths of the state of California. Mm-hmm. And if their child moves in, there's no property tax increase. So it's an issue for those of us who live around here where property values are more substantial, which I think is why they were unsuccessful in getting the signatures needed to get it on the ballot. Also realize there's a lot of interests that love Prop 19. It was the Realtors Association that spent $39.5 million of the $42 million spent to support Prop 19. More homes are being sold because people can't afford to keep them. So realtors, of course, have a logical interest in more property sales. Maybe we all do.
Yeah,
There are
and
also, yes, Mark.
yeah, well, unions, California
Well,
public employees unions, firefighters, teachers, it's going to be billions of extra dollars to the state of California. Have you ever heard of any tax increase that the California government, at least, and unions didn't like? I mean, we had a massive budget deficit this year. I think you would see massive money going in to fight any repeal efforts, even if it made the ballot. Now, we can't predict the future, but as I talked about before, hope is not a strategy. Do not rely on California voters to bail you out if this is an issue. Take action. We're going to talk about what you can do in just a moment. But I also think like the house is not just a structure, it's the home. You know, people grow up in their home. We have a lot of people who they're not high net worth. They just happen to have grown up in Los Altos or Palo Alto or West Los Angeles or San Diego, and maybe their child is a teacher and they live there their whole life and they just want to stay in mom and dad's home. That's it. And they just want to save it. This isn't even really about taxes. It's just about the ability to stay in your family home. And especially if you have a child with special needs, maybe that's their comfort zone. Maybe that's where they feel most at home and most themselves. So it's so important. And I just want to tell a quick story to illustrate the issue. So calling us too late. This is a quick story. We are now known pretty well across the state of California as Prop 19 planners because we have a lot of videos about one of our videos has been seen over 160,000 times. And we get a lot of calls from people about Prop 19, some of whom we can help, some of whom we can't. I got a call a couple months ago from a woman. She was a teacher and her parents had passed away her mom had passed away a year before. Her dad had already passed away a few years before that. She inherited the house in Mountain View. The house was worth about $3.1 million. It wasn't a big house. It was just a normal ranch style home. She just wanted to stay there. She didn't know about Prop 19. She inherited the house, thought everything was good. Then she got a tax bill in the mail. It was a supplemental bill for over $28,000. She did not have $28,000. All she got from her parents was the house. They were just a middle-class family that happened to own a house in a good area. And she frantically was calling and saying, hey, I know you guys know Prop 19. What can we do? Like, what can we roll this back? Can we fix this? And my answer was no. There's really not anything we can do. Your mom passed away already. It's already your house. Maybe you can get the $1 million in protection, but we cannot roll back the taxes to where they were before. Once they go up, they will not come back down because she called us too late. If her mom had called us while she was still living, there were a lot of steps we could take. We'll briefly go over what you can do. I think the big picture is you need to plan ahead. While mom and dad are still around and while they have capacity, if they take steps ahead of time, we can keep the taxes low where they are. But once a parent loses capacity or once they pass away, it is extraordinarily difficult, if not impossible. So I want to share some numbers just to really hit home how massive this problem is. Because sometimes when we go to these numbers, it strikes me that Prop 19, at least for property owners, represents the largest tax increase in California history. Here's why. Let's talk about an example. Let's say there's a $3.3 million home. Now I know that's only in certain areas of California is that the norm, but a lot of California it is. West LA, San Diego, Orange County, Bay Area. There's a lot of fairly normal homes worth over $2 or even $3 million. Let's say that the assessed value when mom and dad were alive was $300,000 and the house is worth $3.3 million. Let's say the children inherit it and one of them lives there. So they get the $1 million in protection. So property taxes go up from about $3,300 a year to over $25,000 per year. That's with the $1 million protection. Now let's look at these numbers over a number of years. This is not just a 1-year increase. This is the increase forever going forward. And then there's 2% increases every year. So over 5 years, that's over $114,000. Over 20 years, over $500,000. Over 30 years, almost $900,000 in extra property taxes. And keep in mind, you can only deduct the first $10,000 in property taxes from your income taxes. So for your child to pay an extra $892,000 in property taxes, they would probably have to earn an extra $1.3, $1.5 million in income over the 30 years just to hold on to the same home if you don't plan. If you plan, we can stop that. We can help you prevent that. Let's give an example. If the house is not the primary residence, or if the child doesn't move in, or if it's a rental, same numbers, $3.3 million home, $300,000 assessed value, the numbers are even bigger. So they go up from $3,300 a year annual taxes to over $36,000 per year. Over 10 years, $360,000. Over 30 years, almost $1.34 million in extra property taxes. I mean, they would have to earn almost $2 million in extra income. That's a lifetime of earning for many people just to hold on to the same house. So the tax increases are incredible. And if you leave a property to a special needs trust, well, the special needs trust is responsible for paying the taxes. So just think about the difference of $2 million or $1.5 million has to go to the state of California in property taxes versus what it could do to support your child if you keep the taxes low. So what can we do about it? Happily, our firm has developed solutions. We're not going to go into too many details here because it's complicated, but we just want to let you know our firm has developed, let's call it the Gilfix La Poll Dynasty LLC. We've helped hundreds of California families with this. And it's really important that this is not just a one-size-fits-all solution. We utilize a combination of entities and specially designed trusts because we've seen people come to us saying, oh, here if I do like an LLC that solves it. First of all, don't try this at home. If you make one small mistake in this type of planning, you can trigger an immediate and massive increase. But a lot of solutions don't take into account the three taxes that we have to think about: property taxes, but also capital gains taxes, and even estate taxes. So our approach optimizes for all. You don't want to take some step that keeps the property taxes low, but then your child loses the crucial step up in cost basis when you pass away. That's a different subject, but we don't want to solve one problem but create another. And I think the big picture point that we want to make here is over it takes several months of work. This is not a one-step process. It takes several months of work, and there's no one-size-fits-all solution, but we can optimize no matter what your situation is. We can optimize to eliminate capital gains taxes and keep property taxes low. We don't solve one problem but create another. And if you have estate tax issues, we can help optimize for that as well. And the return on investment for this type of work is breathtaking. I mean, we can show clients we can deliver a 20 times return, a 30 times return on the investment required to do it. So I think the main point I want to make here is if you have property in California and even if the property taxes are moderately high now, and you want to keep them where they are, especially if they're low, you need to call us now. Tell your friends if they want to leave property to their kids, tell them to talk to us to at least we can break down the problem quickly, show them the problem, and show them potential solutions. We've helped so many families with this. We have, I think, extraordinary solutions developed by our tax guru, Francis La Poll. It's extraordinary what we can do when we plan ahead. So talk to us if this is an issue. Set a meeting with us. If you're a current client, set a meeting. Let's review it for you. Every week, more people are hiring us for this. And don't solve one problem and create another. So don't dabble in this. Work with people who really know this. We know it backwards and forwards. Any final thoughts about Prop 19, Mike?
You said the most important point. I mean, if there's any desire, special needs situations, most of the time there is a property in the family that you want to keep there for your child. Most of the time, we've counseled hundreds and hundreds of folks. So this has to be top of mind for you. This isn't something, oh, gee, it's an option. Honestly, I view this as a necessity if you want to create opportunities for your child.
So now let's transition to a different subject. We talked about a special needs trust as a financial and legal safety net. Well, how can you ensure there's enough for your child, and how much should be there? Like, how do you even know how much is enough, and how can you make sure that there's enough there? The numbers are pretty big, right? For someone with this, there's some recent studies. Let's talk about this, Mike.
Now, this is, it's a moving target. How much is needed? It depends on so many factors. Does the person have a need to be in an institution? Are they homebound? Do they need a caregiver? Are they able to do anything for themselves? Do they have housing taken care of? So this number came from a study done quite a few years ago, and the number is bigger now. It was dealing with autism, average life expectancy. It would include the cost of housing. So it's a lot. If you can take care of the housing component, you've taken a giant step forward, and it reduces that number dramatically. That's maybe one of the most important points to make. We are concerned that the vibrancy and the adequacy of government programs they're very questionable. The number of folks who are disabled and need government benefits, that number is increasing on a daily basis. Are the resources from government programs increasing on a daily basis? They're not. They are absolutely not. So we have a demand curve that's going way up and a supply curve that's about the same or maybe even dropping. So again, it underscores the need to maximize eligibility for government benefits, take a realistic look at your situation with your child, and do the very, very best you can. Most don't have this much money to set aside. We know that. This is just the results of a study.
And here's another way to look at this. I like this framework for when you're thinking about how much is enough. So think of a special needs trust. It's kind of like when you retire. When you retire, the idea is you're not going to get any more income. Now you might have a pension, you get some Social Security, but let's assume you don't have a pension, there's no other income. What are the general rules of thumb when you retire for how much money you can take? Well, at least historically, the general rule of thumb was the 3 or the 4% rule. So you could take out about, if your money was invested reasonably well, you could take about 4% per year without invading principal. So if you had $1 million set aside, invested well, you could take about 4% of that per year, $40,000 a year. And in theory, that should last indefinitely. The $1 million should not be invaded because you're getting it from a combination of dividends or income or capital gains returns. So I think that's a useful framework when you're thinking about special needs planning, because there's likely not going to be any new money coming into that trust after you leave money to it up front. So how much is needed up front? So again, back out, what is 3 or 4%? What has to be true for 3 or 4% of what's in the trust to be enough for your child? So let's say that your child needs about $3,200 a month in support. And you can say maybe they'll get some government benefits, but I think I would sleep well at night knowing my child has an extra $3,200 a month from the special needs trust. Well, 3,200 times 12, I'm not doing the math exactly, but it's about $40,000 plus or minus. So then $1 million in the special needs trust should, you never know, but should be about enough. And you can increase or decrease those numbers from there. Usually it's higher. If they need 80,000, you need $2 million in the trust. If they need 120, you need 3 million in the trust. And you might be thinking, well, Mark, that is great. That I would love to have $3 million to leave to my child's special needs trust, but I don't have that. What can we do to fill this gap? Now, there's no perfect solution here, but Mike, why don't we talk about one of the most powerful tools that we see? How can we be certain that there is that safety net in place? What is the powerful tool that we use a lot?
Yeah, inevitably, any advisors who work in the world of special needs, inevitably the topic of life insurance comes up. Life insurance is no panacea. There's many situations where it doesn't make sense, but here it can make a great deal of sense. Locking in a death benefit, naming the special needs trust as the beneficiary. So I want to give you a real life story that just makes this point very, very profoundly. This was a number of years ago. A couple came to see me. They had 2 children, one of whom was profoundly sick, severely disabled. It took 30 to 35 minutes to give that baby a meal using a dropper. It was physically limited, 0 mental capacity, but a reasonable life expectancy for a number of reasons. And the parents were worried to death. And they came to us to think about the special needs trust. Their other child was just fine. They decided that they had no choice but to leave virtually everything in the estate to the special needs trust, which made them very, very sad, like they were doing the wrong thing for their other child. There were tears flowing in the room. Importantly, by the way, the wife's mom and dad came along to that meeting, and we ultimately recommended they think about life insurance and options that might be available. And we had them meet with a professional who has experience in this world, and they were in their 40s, relatively young, healthy, and he developed a number of options so that they could purchase a $1 million life insurance policy. The 2 main options, the best deals they could get, one was that they would pay about $4,300 a year for the rest of their lives and lock in this $1 million death benefit. It would go exclusively to the special needs trust. The other option was they can make 1 premium payment only, 1 payment upfront, $60,000, and the policy is bought and paid for. And it would, again, lock in that $1 million. They didn't have that much money, but the parents were there. And they put in about half of the money, and between the 2 of them, they came up with the $60,000 to buy that policy, and it went into place. After that happened, the wife, in a telephone discussion I will never forget, the wife called me up and she thanked me. She said this was the best solution ever. And she said that because they just felt liberated, their mindset changed. She said 2 things. Number 1, we now feel that we can leave a portion of the estate to our other child. And she was crying, and she got me crying on the phone. And she said that because of this also, for the first time, they actually had a different mindset. They felt that they could actually take one night off and go down to Monterey and leave the grandparents with that child. It triggered this sort of this avalanche of good feelings and feeling of liberation. So a life insurance policy, it's something that can be a critical role, almost, I hate to say savior, that's an overstatement, but a critical role as you think about these options.
Yeah, it's not possible for everybody. We know this, but
Mm.
we just urge you. We work with some incredible life insurance and financial advisor experts, and we encourage you to speak with them. If you have an old life insurance policy, you may be able to trade in for a much better one. Bottom line is, if you don't have it and you want to explore it, talk to us. We can connect you with somebody. And if you have an old policy, talk to us as well, because there are actually amazing opportunities to often trade them in for better policies at no extra cost. It's pretty amazing. So here are just the numbers that Mike talked about. It's amazing. This doesn't fit everybody. This is just illustrative, but it can be a real lifesaver for many people. Pardon my pun there. I guess it's when your life is over.
Hey, that's right. Wait a minute.
So there's other ways to fund it as well. It's not just life insurance, of course. You can do retirement accounts. So it's really important, if you have a special needs trust in place, to direct your retirement account or share of it directly to the special needs trust. We see this mistake a lot where people have a retirement account, it's directed by beneficiary designations. You need to make sure that that you name the special needs trust, not your child, as the beneficiary, or you can route it through your living trust. Really importantly, there's a new law in retirement accounts, this is for everybody, called the Secure Act. And what does the Secure Act mean? It means that inherited IRAs, used to be if you inherited an IRA from your parent, this doesn't apply to spouses, but if you inherited from a parent, you just had to take a required minimum distribution every year based on your life expectancy. So if you're in your 40s when you inherited an IRA from a parent, you had 30 plus years to take that money out and pay taxes on it very slowly. The Secure Act limits that to 10 years for everybody, except there's some exceptions. So it speeds up the time over which you have to take that money out and pay higher income taxes in theory. Special needs trusts, if the beneficiary has a disability, do not have to take the money out within 10 years. They can stretch that over the child's life. So there's a benefit of leaving special retirement accounts to a special needs trust. Very important to remember that. And I think very importantly, it's not just retirement accounts. Maybe it's just investing well. Make sure that you have a good financial advisor or a good approach to investing, a balanced portfolio, tax efficient market-based investing. So make sure that your money is invested in growing. We have crazy inflation now. Keeping money in the bank is not keeping up. So if you want to self-fund the trust, meaning there's no life insurance or anything like that, make sure you have enough there. Make sure you're working with a good financial advisor. If you have real estate, you might have a great cash flow positive rental property. Have you dealt with Prop 19? It might no longer be cash flow positive when it goes to your child if you didn't deal with that. Sometimes annuities can be nice things where you pay up front and it can give guaranteed cash flow to the special needs trust over time. But I think really importantly, it's important to work with an integrated team. When it comes to this, don't leave this to chance. And what does this mean? It just means one hand should be talking to the other. Your financial advisor should be talking to your attorney. You need to make sure your beneficiary designations are up to date, your accounts are titled properly, that your plan is consistent with new tax laws. So this is something that we are big believers in. We work with many financial advisors. We're happy to talk to yours. If you're looking for a new advisor, talk to us. We have a couple of advisors in a network that we're building where our clients work with them. We coordinate with them. There's no extra cost to clients. We can make sure that one hand is talking to the other. So make sure you're thinking about your child's future. Use that 3 to 4% rule to figure out how much you're going to need. Do you have enough? Are you invested well? Are your retirement accounts directed properly? Is there a gap? Maybe life insurance is a possibility. Are other family members perhaps going to leave money to the special needs trust? Have you coordinated with their attorneys? Have you communicated with them? So there's so much we can do, but you have to plan ahead. Let's now transition to some updates. We're getting towards the end of our talk, but let me make sure I'm sharing the right screen here. So let's talk about some just quick updates in the special needs planning rule. Mike, why don't you lead us through some recent changes in rules and just some beneficial changes in law as it pertains to special needs planning?
Yeah, the first thing I'd like everybody to be aware of is the ABLE Act. It's federal legislation that has been implemented in California, and basically it means that anybody can put up to $18,000 a year into an account. It's like a 529 plan in the sense that it grows tax-free. It can hold up to $100,000, and none of it interferes with eligibility for government benefits. In some ways, there's more flexibility with an ABLE Act account than there is with the special needs trust. Money remaining in that trust when the child passes away, there's not a payback to the state. And what I like about them is that the child herself can be the manager of the account. Many kids are not able to work, but let them have a little bit of money in an ABLE Act account. It can hold up to $100,000, but rarely do we recommend that you do that. Maybe it's going to hold $3,000, $4,000. And again, you let the child herself manage that money, have a checkbook. You can imagine how many issues that can address in a very supportive way. It's like respectful of your child. So you need to know about these vehicles. They do not replace a special needs trust. They can be complementary. They're part of the planning process. One of the options for you to know about and for you to think about. The care courts. The issue that we worry so much about is that if somebody is facing a mental health crisis, bipolar, schizophrenia, for whatever combination of reasons, it usually takes a crash and a burn before the system can intervene. The person must become a danger to herself or others before something called a 5150 that you might have heard about, before that can be imposed, so that the person can be hospitalized, be given psychotropic drugs. A series of protections come into play, but only in extreme circumstances. And parents go crazy. They can see their child cruising down the wrong path. They can see it coming, but they can't do anything. So we now have the care courts, which are one of two options that enable folks in limited circumstances to intervene before the crisis happens. So it is available in our counties locally here. I believe it's in all counties, but I'm not sure about that. Counties have to implement this. So
it's a positive development.
So the individual who might be the focus of a care court initiative is given a tremendous amount of support. They get a lawyer, and they get an advocate as well. So the idea here is to be non-intrusive, to be supportive, but not wait until somebody becomes suicidal or attacks somebody else to go to extremes. There's also something called Laura's Law, which we don't have up here, which is another way of intervening before the crisis happens. There are some gentle movements in that direction, thank goodness. The McGee case, it's just worth mentioning, we do track legislation. We do track court cases that bear on these issues. The only thing to say about the McGee case is that it reinforces everything that Mark and I have said about the flexibility that a trustee has when it comes to using money in the special needs trust. The McGee case basically says, yes, a trustee should have great flexibility. They know better than the courts. Judges shouldn't be second guessing these things. So it reinforces everything that we've been saying.
Britney Spears concert tickets or Taylor Swift
there you go.
It's probably okay. So this may not be an issue for many people here, but it's really important to know about estate and death taxes. There is a big cliff coming. Let's talk briefly, because this may impact many families, especially in the Bay Area or the more affluent parts of California, the estate and the gift tax. There's a big change coming. Now, currently, you can pass up to $13.61 million per person. That, for a couple, that's over $27 million to your kids or anybody else, tax-free. There's no estate or gift tax on the first 27 million for a couple, or 13.61 million per person. But there's a cliff coming. And that cliff is coming most likely on January 1st, 2026. At that time, barring a major and unexpected change in law, the Tax Cut and Job Act that was passed, I think, in 2017 will sunset. When it sunsets, the estate tax exemption will be cut in half. It's indexed with inflation, so it'll go from about 14 million a person to about 7 million a person, most likely. Now, you might think, well, that's not a big, maybe it doesn't impact you. And to be clear, it's a good problem to have. But if you own a house in many parts of California, that alone might get you close to it, especially if you're single. Keep in mind, life insurance, unless it's in a special trust, is part of your estate. A future inheritance is part of your estate. Retirement accounts are part of your estate. So if you're even close to those numbers, you need to be aware of this, because it's use it or lose it. As in, when the exemption drops, if you don't use the larger exemption before it drops, you don't, like, if you gave away 7 million when it was 14 million a person, you have 7 million left. If it drops to 7 million, you might think, well, oh, I'm good, I had 7 million left. And that's not the case. If you don't use all 14 million before the deadline, you lose that opportunity forever. We know this is not an issue for many families, but if you're close to this, and these numbers are the rules of thumb we're kind of thinking about. If you're single and you have a net worth of over 5 million, or a couple with a net worth of over 10 million, we have to be aware of this. We have to talk about this. There are so many tools we can use to reduce or eliminate estate taxes if we plan ahead. And of course, we're going to know a lot more after the November elections, which who freaking knows what's going to happen there. This is the most crazy time maybe in modern political history, but we have to be ahead of the game. So we can help with this. If you face these issues, talk to us.
Sure. And keep in mind, the estate tax is a 40% tax.
Yeah, it's punishing. and yeah, 40% of what you work so hard for and already paid taxes on, income tax, is going to be taken again. So it's often we talk about politicians proposing a wealth tax, and there's arguments for and against it. The estate tax really is a wealth tax. It's a one-time tax, but it is a wealth tax. So, but you don't have to be super wealthy for it to hit you if you own a house in certain parts of California. So now let's tie this together. What are some steps? This 2024, let's talk about a special needs planning checklist. You can take notes here. What do you need to do? If you have a child with special needs or a loved one with special needs, what are the steps you need to take? What do you need to pay attention to? We want to give you a framework. There's a lot of things here, but maybe not everything applies here. But what are some of the steps you need to take? Well, first, you have to make sure that you have a comprehensive estate plan in place. Your plan is only as good as the weakest link. You have to have up-to-date living trust that is the right structure, up-to-date backup trustees, powers of attorney, advanced directives. There's other trusts you can create for other kids if they don't have special needs, family protection trust, dynasty trust, very powerful tools you can put into place. Do you have the right living trust structure? Do you have the right successor trustees? Do you have a child or grandchild with a disability? Is the special needs trust in place? Is it up to date? Did you set up other trusts for your other kids? We have many talks about family protection trusts. It's not just special needs planning. If you have other kids who don't have special needs, we can protect them as well. You have a larger estate. If you plan for the exemption dropping, have you made annual gifts to your loved ones? Are other family members potentially going to leave money for the benefit of your child with a disability? Have you coordinated with them? Do they know you have a special needs trust in place? If you own California real estate, have you dealt with Prop 19 and property taxes? Have you reviewed your financial and insurance plan? When was the last time you worked with an advisor or had someone review your financial plan, your insurance plan? We can help with all of this, of course. Like this is what we do. We are not financial advisors. We're not insurance brokers, but we have an amazing network. People can help, and we can make sure the estate planning side is covered. And again, it's not just the special needs trust. You need to have all these other tools up to date. Revisit your plan at least every 3 to 5 years. And I think it's really important. Our team is not just Mike and I. We have 7 estate planning attorneys now. We just added to our team. And we have over 140 years now, 120, 140 years of experience, not just us. So we have a team that can help you. We all work as a team. I just want to revisit the concepts I talked about at the beginning. When you are dealing with special needs plan, let's tie this back to the beginning. You may feel like I'm afraid to die, but hope is not a strategy. Let's control what we can control. And there are very few high leverage moments in life where you take one step now and it can reverberate across multiple generations. It can mean the difference between an abundant and wonderful life for your child with special needs or one where they're virtually abandoned and there are no resources available for them. Make sure you have that comprehensive estate plan in place. Let's control what we can control. Let's make sure that you're not leaving it up to chance, and don't rely on California voters to bail you out if you have property tax issues. So if you work with us already, let's set a meeting. Let's review your plan. If you haven't, we invite you to join our client community. Reach out to us at gilfix.com or 650-493-8070. Easy to find us. Set that planning meeting. Let's review it. The stakes are too high to leave this to chance. If you haven't subscribed to our Gilfix Law YouTube channel, subscribe to it. Easy to find us. We're up to about 3,000 subscribers at the time of this. Hopefully by the time you're watching this on YouTube, it'll be even more. But if you are watching this on YouTube, like, comment, share, leave a question or comment for us if you have any questions. We're going to get to some questions in just a moment, but contact us. You know where to find us, gilfix.com. Very easy. You can call us at 650-493-8070. We have another number listed with our online listings. Both work. But talk to us if you're not sure. Just talk to us. A little bit of planning can have massive impacts on the future. So we're going to get to some questions now. We have one question from Ed. My spouse and I already have a living trust. So how much do we charge for modifying the trust, creating a special needs trust, and setting this up? So Mike, how would you, so let's talk about how do we structure fees and how do we go about this?
Well, to some extent, it depends. We don't know what the structure of your trust is. Typically, when we do a special needs trust, the fee is between $2,900 and $3,100. Typically, it could be a little bit more. It's rarely less. If we have to undo or redo your trust, we would do a restatement of your trust. Keep the same name and date. Nothing has to be retitled. Fee depending between maybe $2,200 and $3,200, something like that. And we do charge for consultations, so there'd be a little bit more than that. But you got to do it. And by the way, another question that I see is not unrelated. Is if a child suffers from bipolar disorder, a different person, can they still sign a power of attorney or an advance directive? Yeah, because it's at the time of signing that the person has to have capacity. So if you're bipolar, kind of by definition, you're going to have times when you're very clear and you can do your planning. You can undo it when you're manic, but you can. And what if you're on the autism spectrum? Same answer. Many individuals are of a sufficiently high level of functioning that they can sign and understand the basic idea of a power of attorney and the advance directive.
That's important. And I saw a couple people raised hands. Actually, enter your question in the Q&A function. If you have that, we can get to that. The raised hand stuff, I screw that up on the technical side. So feel free to enter a question in the Q&A function.
All these young people, they're just low tech. They just don't understand these things like I do.
Yeah. Here's a good question from Victor. How is special needs substantiated? I think that's a very good question. So I think bigger picture, and this is kind of an adaptation of that question. Does your child have to have a specific type of disability for you to create a special needs trust? And the answer is no. We have clients who create special needs trusts for their children who have no specific diagnosis. They're just worried about them. They're not sure if they're going to need government benefits. So from the special, there's no requirement that your child have any specific diagnosis or even special needs to create the trust. You create a special needs trust for anybody, right? It's just that the trust is designed for them to receive government benefits if they are otherwise eligible. And that's where the special needs definition or the diagnosis of some sort of disability is required to be eligible for those government benefits. And Mike, what is the definition? It's really just about maintaining employment.
Yeah. So the kind of the definition of disabled in the context of government benefits is that a person is not able to maintain substantial gainful employment. In other words, they can't get and keep a job. They can't make a living. And that has to be documented. There has to be a documentation of either a physiological, psychological, mental health issue. But again, you put that some evidence together with the history of the individual, and that's how you establish disability in the context of government benefits.
Absolutely. We have a couple more questions. So what about tax issues? So we're talking about structures. This is not the question here because I think the question here, one question is not really relevant, but how are special needs trusts taxed? That's a question we get a lot. So a special needs trust is its own taxpayer. It has its own tax ID number. And if a special needs trust just has cash sitting there, it doesn't generate any income, well, there's nothing to report. There's nothing to pay. But if the special needs trust generates income, there's two options for how it's taxed. If the special needs trust holds on to that income and doesn't distribute anything to the beneficiary, the special needs trust files its own tax return and pays income tax on that. Trusts do have an accelerated income tax schedule, so they reach higher income tax rates at lower dollar amounts. But if they use the income to benefit the beneficiary, they will typically issue a K-1, and it's counted as the beneficiary's income, which is usually what you want because the beneficiary probably has a lower tax rate than the special needs trust. So important to understand that. It's not, that's really the impact of how it's managed once there's money in the trust, once you're gone. So there's a couple other good questions. Let's just make sure, there's one about Medi-Cal planning. Mike, do you want to go over that one from Scott? What type of Medi-Cal planning expertise do we have? Are there any strategies to adjust countable income to qualify without cost sharing for assisted living, IHSS, or other support?
Okay. So Medi-Cal is, last question, I think, for interest.
Yeah, we'll wrap it up.
Medi-Cal is California's version of the federal Medicaid program. Generally speaking, it's a needs-based program to make sure that people who are over 65 or younger and disabled get medical care. Okay. California, this next point is only about California. California on January 1, 2024, just a few months ago, eliminated the asset cap on eligibility for the state Medi-Cal program. So millions more people now qualify. If an individual enters a nursing home, for example, they are going to immediately qualify for Medi-Cal if they want to take advantage of the program. There's pros and cons. There's still planning to be done, but Medi-Cal has exploded in terms of eligibility here in the state of California. IHSS is kind of a subset. It's got some different rules. Almost as liberal, but there's other factors before somebody can qualify for IHS, in-home support services, IHSS. So complicated question there. Everything has to be coordinated. I think that will do it, Mark.
Yeah, I think that's it for today.
We have a little over the hour.
Yeah, we're there. We have a lot of good questions. So thank you guys. I'm sorry we can't get to actually, one last question. I guess just raise estate taxes because it's a good question just to clarify. So this question is, if you give away assets now worth $5 million and the future exemption is $5 million, are you left with no exemption when you die, when the current amount sunsets? Yes, whatever you give away, That's what they count against whatever the limit is at the time that you pass away. So if you gave away 7 million when the exemption was 14 million, you had 7 million left. If later the exemption drops to 7 million, it's not like, oh, I didn't use the other 7 million, I have that left. No, it's what they just look at whatever you gave, and that's it. So it's use it or lose it. If you have these issues, plan ahead, we can help. So I think on that note, we're going to end. So contact us, gilfix.com. Follow our Gilfix Law YouTube channel. We have a lot of short videos, Medium. We're going to post this there. If you're watching there, share, like, comment. Let us know if you have other questions. Spread the word. You guys now know more than 99% of the population. If you know anybody else who could benefit from this, share this with them. We can help. But thank you so much for joining us here today. We will see you next time, and stay tuned for more webinars and videos on our Gilfix Law YouTube channel. Thank you so much.